I'm Donna Martinez. Welcome once again to another December edition of Virtual Shaftesbury Society. We're coming to you live from the headquarters of the John Locke Foundation in Midtown Raleigh. Glad to have you all along because we have a great discussion planned for you today. Gun rights, abortion restrictions, federal executions. This term, the United States Supreme Court has already heard arguments over some of the most consequential issues of our time. And today we have two legal experts with us who are going to give us perspective on the key issues in those cases and if we've been able to actually glean anything from oral arguments about which way the United States Supreme Court might be about to go. But we're also going to give you an update on several key legal cases related to North Carolina that aren't before the U.S. Supreme Court, but are very big issues that are actually occurring right now. We've got several different things we're going to talk about coming up here with our guests. First of all, Dan Gibson is a partner with Stam Law Firm located in Raleigh, and Greg Wallace is a professor at the Campbell University School of Law. Gentlemen, thank you very much. Appreciate you joining us today. Can't wait to dig into this.
Thanks for having us.
Dan, let's start with you. First of all, on these legal cases that are affecting North Carolina right now, we learned just days ago that our election primary has now been delayed until May of 2022. What is happening there?
So it's yet another issue with redistricting in North Carolina. For those of you who don't know, we have a census every 10 years. And when that census occurs, we draw new maps for our United States and North Carolina House of Representatives districts, new maps for our North Carolina Senate districts too. And it seems like pretty much every time we redistrict, there's a challenge to the maps that are drawn. It doesn't matter which party's in power. I think this goes back to even the 1990s or 1980s that we've been challenging these. Things are a little different this time because the plaintiffs are trying to put everything on hold while the redistricting litigation goes on. Basically, the reason why they're asking for that is, let's say you have an election, even a primary election, and people have ran for office in that election. And after that election happens, the court comes along and says, well, actually, that map wasn't drawn correctly. We generally don't do redo elections. So we say, well, the way to fix this is the next election will draw new maps for that. So what the plaintiffs have done here is said, we don't want to wait until after someone who runs under a bad map wins. We'd like to get you to stop it before there's an election on it. There was a lot of technical stuff going on at the Court of Appeals and the North Carolina Supreme Court. First, the elections were stayed, then the elections weren't stayed, then the North Carolina Supreme Court came back in and put them on pause again. So that's where we currently stand. The North Carolina Supreme Court has said, until this trial can happen, which they've ordered to be rushed, we don't want to do anything. So basically, the North Carolina Supreme Court has said, we're going to do this as quickly as we possibly can. This case is going to go straight to trial. When it's done with trial, it's going to go straight to us. Everybody's on an expedited schedule. So hopefully we can have an election done and not have challenges after the election.
Now, in the meantime, the candidate filing has been stopped, correct?
That's correct.
So we have some people who filed for office, and apparently they're going to be, I guess, grandfathered in, for lack of a better phrase. But until there is a final determination from the North Carolina Supreme Court, then we're just kind of stuck. So at this point, we think that the primary is going to take place in May.
That's correct. I expect that it will, given the way that the court has sort of ordered things here. But that grandfathering in of people who've already filed is actually sort of the plaintiff's best argument here, in my opinion, in terms of getting things put on hold, because that's generally what courts do. Once you've registered to run for office, we tend not to sort of claw those things back.
Now, also in the election arena is this challenge that is taking place It's the NAACP that is essentially trying to disqualify, to force off of a key voter ID case 2 members of the North Carolina Supreme Court so that they couldn't rule on this case, Phil Berger Jr. and Tamara Barringer also. So give us a sense of what is behind that, and is that likely to proceed?
So the argument with Justices Berger and Barringer is fairly simple. Justice Berger, his father, of course, is Senator Phil Berger, who is the president of the Senate. In North Carolina, when you sue saying a law or a constitutional amendment is unconstitutional, one of the people you have to sue is the president of the Senate. So Phil Berger, the senator, is named as a defendant in this case. So the argument is, well, you probably shouldn't be ruling on your father's case, so we don't want you involved in this case. For Justice Barringer, it's a little bit more complicated. She was a legislator before she was a justice, and she voted on the legislation that's being challenged here. So the argument is, you voted on this legislation, so because you voted in favor of it, presumably you think it's constitutional. We don't think you'd vote for legislation that is unconstitutional, so we want you off of this as well. There's been an interesting development that I don't think has been quite as well reported, which is Representative Moore and Senator Berger have also moved, if the court decides to recuse these justices, to also recuse Justice Anita Earls, who has some connections with the North Carolina NAACP. So they've sort of tried to tie in, hey, we don't think you should recuse these justices without their consent. But if you do, we'd like you to recuse her too. And I'll say on that issue.
Is that sort of an argument of, we don't agree with your reasoning, but if you're going to use that reasoning, that same reasoning should be applied to another member of the Supreme Court?
That's exactly the argument they're making. They're saying, don't do this, but if you're going to do it, at least do it consistently. And there's some merit to that. I don't want to get too into the specifics here. I wrote an amicus brief in this case. I do a lot of work at the North Carolina Court of Appeals and the North Carolina Supreme Court, and I'm very concerned with the court removing justices without those justices' consent. I think that's akin to impeachment and removal. I don't think it's a power that the North Carolina Constitution gives the North Carolina Supreme Court. If you think a justice is hearing a case, or a judge is hearing a case that judge or justice is biased on, then there's 2 ways to solve that. One is you vote him out of office. The other is you follow the process in the North Carolina Constitution for removing a justice, and that's impeachment and removal from office through the General Assembly or through the Judicial Standards Commission. I think once we open the doors outside of that, we're just inviting trouble. There's all sorts of. Go ahead.
And there's also an issue there about whether or not a forced recusal would essentially disenfranchise several million North Carolina voters who in 2018 voted to enshrine a requirement for a photo ID in the state constitution. And so it gets into that question. Are you comfortable talking about that issue, or do you want to kind of stand back because you do work there?
Well, I'll say, when it comes to that's actually very related to the concern I have about just generally involuntarily removing judges and justices. In North Carolina, we elect them. The people get to choose who our judges and justices are. It's in our Constitution. And that's why you should act through the General Assembly if you're going to remove them. Because, the people didn't know about this particular case when they elected these justices. So the people's representatives should be the ones that are entitled to act through the General Assembly, because they're there to represent the voice of the people. So there's this new information that's come along. We don't know necessarily how people would respond to it if these justices go along and hear this case anyways. So rather than the court trying to act as the representatives of the people, they should allow the General Assembly to act as the representatives of the people, rather than nullifying the people's vote for these judges and justices.
Now, I'll also let our viewers know that here at the Locke Foundation, and specifically at Carolina Journal, investigative reporter Dallas Woodhouse has been working on a podcast called Extreme Injustice. And if you go to extremeinjustice.com, you can listen to several editions of that podcast talking about the issues in this whole case and this question about forced recusal. It's a great resource to get yourself up to speed on exactly more about what's going on in this case. Dan, I'd like to move to the third item here of great interest in North Carolina, the legal case involving the education funding battle that's been going on for several decades here, commonly known as the Leandro case. We have a question now, an order from a Superior Court judge essentially saying that the General Assembly should be bypassed and that state finance officials should move, I think it's $1.7 billion out of the coffers over to education agencies. Seems like a violation of the Constitution. Tell us about that case.
So what's happened there is Linda Combs, who is the state controller in North Carolina, and I only just recently learned that she's really the one who moves the money around. I had assumed that it was the state treasurer here, but actually Linda Combs and the OMSB, the Office of State Management and Budget, are sort of the two forces that get money out of the state coffers and to wherever it's going. So in two separate cases, one is a case involving the Hoke County Board of Education and the other is Leandro. She's said, I can't give any money out unless there's an appropriation from the General Assembly, because the North Carolina Constitution is pretty clear on this point. It says no money shall be appropriated, essentially without the General Assembly appropriating it. We don't get to give money out without the General Assembly doing this. So her argument is, you've put me between the devil and the deep blue sea, because I have a court ordering me to do one thing, and I have the Constitution and the General Assembly ordering me to do another thing. So I don't know what I should be doing here. At the very least, you shouldn't make me do anything until the North Carolina Court of Appeals or North Carolina Supreme Court can be heard on this issue of which is the higher authority. Because there's a pretty clear, the order doesn't leave a whole lot of questions about what it wants Combs and State Treasurer Dale Folwell to do in this case. So I really feel for her in this situation, because if I was her attorney, I don't know what I would tell her to do. It's generally not a good idea to disagree with a judge who can hold you in contempt of court, but it's also generally not a good idea to just disregard the North Carolina Constitution either.
Fair to say that we're lined up here for a constitutional crisis?
I think these are very, very important constitutional times for North Carolina. It's hard for me to think of a situation, certainly in recent history, where we have had so many critical questions on so many different fronts, all happening at the same time. None of these are small issues. Whether or not you can take money out of the Treasury without the General Assembly is a massive question. Whether or not you can take a justice off of the North Carolina Supreme Court without that justice's consent is a massive question. The merits of that case, the voter ID question, is a big question. It sounds strange to say the redistricting cases are small by comparison, but redistricting is sort of something of a cottage industry in North Carolina. I suspect as long as we have the General Assembly or really anyone drawing districts, we're going to continue to have redistricting litigation. So that's nothing new, but the others are fairly important.
Well, I'll tell you what,
there's one more that I suppose I would add on there too, which is the United States Supreme Court has gotten involved as well in one of these voter ID cases. It's slightly different to the one that's in front of the North Carolina Supreme Court. North Carolina Supreme Court's deciding the merits of that case, whether or not the voter ID constitutional amendment stands. What the United States Supreme Court is dealing with is essentially, in North Carolina, the Attorney General acts as the state's attorney. He's the one who defends the state in court, defends state laws constitutionally. Now, we know where the North Carolina Attorney General stands on this voter ID law. He hasn't left us guessing. He's not a big fan of it. So the General Assembly wants to go hire outside attorneys to represent them rather than having an attorney who doesn't really agree with the underlying legislation, maybe might not take the best course in defending the legislation. So that question is in front of the United States Supreme Court, whether or not the General Assembly can hire a different attorney or has to act through the state attorney general. So that should be an interesting constitutional case as well.
Boy, consequential issues and times. Greg Wallace, I'd love your just general reaction to what you've heard here about, do you remember a time where such critical issues have been plaguing North Carolina with these lawsuits and constitutional challenges?
I have not, and I think Dan has done a tremendous job summarizing the issues in what really are very complex cases here. And I share his concerns wholeheartedly. One thing that is particularly troubling to me is the prospect of collusive lawsuits between certain advocacy groups and state officials, like a state attorney general who, if he wasn't the state attorney general, he'd probably be a member of one of those advocacy groups. And I think we saw this a little bit last year in some of the litigation over the new election rules that were proposed, and whether the state board of elections could change the rules right before the election without legislative approval. And essentially, Attorney General Stein settled the lawsuit and gave the challengers everything they wanted in that regard, at least all the important things. And so I'm very concerned about this Supreme Court decision as to whether the state legislature can also defend a lawsuit that when there is some question about how vigorously the state attorney general is defending it.
Pretty fascinating. And Greg, you and I have talked previously about what's happening at the federal level with the expansion of executive power. And we've seen this with President Biden. And obviously, he's not the only president. People get into office and then suddenly, they become fans of the power of that particular branch of government or their particular office. But he has been robust in trying to expand the use of federal power. And now we've got a lot of interesting pushback when it comes to the COVID-19 vaccine mandate that the president has been trying to institute through OSHA, essentially a labor rule. But now we've had several groups push back, and we've had some court rulings. Give us a sense of where you think this is and where it's going.
Well, the question of whether the president of the United States can mandate either directly or indirectly, as through the OSHA rule, people to get vaccinated is going to turn largely, or at least in the first instance, upon whether he has the power to do that. We don't even get to the question of individual rights and whether the government can order me to, ingest something in my body there and that kind of thing, before we have to look at the powers question. And so you have a number of vaccine mandates at different levels. I think the president has ordered government employees and the military to be vaccinated or under the threat of losing their jobs. I think that's probably a fairly safe mandate from his perspective because of his relationship to the executive branch and being the commander in chief. But when you go from there to the healthcare workers, under the Medicaid and Medicare rules, and then you go to the government contractors, and then you go to the one you're talking about, their private employers under this OSHA rule, things began to get a whole lot more uncertain with respect to whether the president has the power to do this. And we're already seeing courts. We have a couple of courts, one in Missouri and one in Louisiana, which enjoined the federal government from using the Medicaid, Medicare regulations to require healthcare workers and related fields to get vaccines. These are at the district court level now. They'll obviously be appealed. The government contractor, there was a judge in Georgia, a district court judge in Georgia, that entered a nationwide injunction. That's a whole separate issue as to whether district judges can enter nationwide injunctions, but he did a short time ago on the government contractors issue. Now, what's interesting is that when we get to the OSHA mandate, this is being litigated under the federal rules for multi-district litigation. And so all of the cases that are challenging the OSHA mandate have been consolidated, and there was a sort of a drawing as to which appellate court was going to hear it, and the Sixth Circuit won the drawing, or maybe in their view lost it. But all of those cases now are consolidated before the Sixth Circuit, which is a relatively conservative circuit, and but it has some really brilliant judges there. Jeffrey Sutton for one, and so it's going to be very interesting to see what they do with that. Now, one of the problems with the OSHA litigation is that under this emergency rule, which they promulgated, that can only be in existence for 6 months. So it's possible that if this litigation is not resolved by that time, then the emergency rule is going to expire. And if OSHA has during that time promulgated a final rule through the normal rulemaking process, then they'll just have to start all over in that litigation. So to be honest with you, I don't see that case really being involved, being over very soon. I think probably this is going to be resolved at the Supreme Court, and the first case that's going to make it up there is more than likely going to be one of these cases on the healthcare workers.
Interesting, on the healthcare workers. Why do you think that would be the one?
Well, I think that it's moving through the courts faster now. And okay. Although I think the OSHA and the private employer mandate is much more interesting, and I think is going to affect a whole lot more people, it's because of the way it's tied up in this multi-district litigation, and because of the potential that the rule may expire before that's resolved. I just think that either the healthcare or the government contractor case is likely to get to the Supreme Court earlier. But the thing about it is that each of these mandates is justified, at least according to the Biden administration, by different regulations, which they claim to be like with the government contractors. They claim it's the Procurement Act that gives them the power to order anybody that's contracting with the government to have all their employees vaccinated, which was rejected by the district judge in Georgia. So each case is going to really present a unique legal issue, because the mandate is based on different regulations that the Biden administration claims gives the president the power to invoke those mandates.
In the case of OSHA, if this is successful, wouldn't that really expand the purview of OSHA? I mean, I think of them as on-site labor rules. Is a company storing chemicals properly? Are there certain safety procedures in place for machinery that can maim people if they are operating machinery? Things that are on site and direct threats to someone physically. but we're talking about a worldwide virus. It seems to me if this were successful, you could essentially make the argument that there could be a mandate against anything.
Yes, and I think that's going to be one of the big questions here, because not only do you have OSHA being the agency doing this under its regulations, but this is also being promulgated under the emergency rule, which requires a much stronger showing of need. And I just don't think that the government's going to be able to show that. Even I mean, you're talking about regulating work site actions. I mean, you typically have to go off the work site to get a vaccine, and can OSHA tell you what you must do on your own personal time after you leave work? That's a critical question there as well, I think. So and then with the vaccines not let's say not performing as expected, then I think again, that's going to change, or has the potential to change, the calculus as far as the so-called emergency here, why it's so important that people be vaccinated.
Dan, your thoughts on this, on the Biden push for a mandate?
Thanks for asking, because I was about to give them. I'm vaccinated. I've got my booster shot and all of that. But for me, this is really just symptomatic of some fundamental problems that we are having with our system of government. Anytime you're relying on the president or the governor to be setting your policies for a long-term situation, something has gone horribly wrong in our system. I would say, especially when you're dealing with the president of the United States making these decisions, because we are a system of representative government and a limited government. So, if you imagine on a spectrum, the government that actually has the most power, certainly in North Carolina, is the state legislature. That's because our state constitution is a limitation on the powers that the state government has. And those powers lie first and foremost with the people's representatives in the General Assembly. It's completely different once you get to the federal government. The states and the people gave the federal government limited powers. So if the Constitution doesn't say the federal government can do it, they can't do it. And then you take a second step away from the legislature and to the executive. And that is a very problematic step. One of the problems that we had when we founded this country was the legislature handing off power to the executive. It was certainly a problem we had here in North Carolina with, for example, Governor Tryon. So our executive in North Carolina is one of the weakest executives in all of the states. And I would still say in some cases, our executive is still too strong. So that's something that we need to be reining in. What should be happening here, in my opinion, is state governments should be acting through their legislatures. Or if the national government wants to mandate something, it should be happening through Congress. But Congress can't pass a law to save its life unless it's giving money out to the various cronies of our congressmen.
A lot of really important cases here and issues at play, and we haven't even gotten to what the U.S. Supreme Court has actually heard so far this session, but all of this percolating right now here in North Carolina or at the federal level as we try to make our way through this pandemic. All right, let's go ahead and get to some of these key cases that the court actually has already heard. Greg, I know that you are an expert in the Second Amendment and gun rights, and you have paid a lot of attention to this case out of New York State Rifle and Pistol Association versus Bruin. Tell us what's at issue there and what you made of the oral arguments. And Dan, at any point, feel free to jump in.
Well, people who favor gun rights and favor the protections given by the Second Amendment have been hoping for another decision from the Supreme Court over the last 14 years, I guess, since the Heller decision back in 2008. we thought we were going to have a case where the Supreme Court could answer so many of the questions that were left open by Heller. But New York moved a couple of years ago to moot that case out. Now we have another case that's before the Supreme Court that challenges a law in the state of New York that that requires you to have a permit to carry a handgun in public. And in order to get that permit, you have to demonstrate some good cause, some extraordinary reason for needing the protection of that firearm beyond just the general public safety risk that all of us face when we go out into our communities. And so that's at issue right now. So far, it's not been mooted. The oral arguments were held last month. And one of the issues is what standards should lower courts apply in determining whether a particular statute or regulation violates the Second Amendment. And Heller wasn't terribly clear on that question. And so I think that's going to be one focus of this case. I think what's going to happen after listening to oral arguments, and as we've talked before, it's always dangerous to try to predict outcomes based on what you hear in an oral argument. But I think there is a majority of justices who are going to vote to strike down this law. And interestingly, the state of New York even conceded that this test that relies on the text and history and tradition to evaluate the constitutionality of gun laws under the Second Amendment is the operative test. Now, we're going to have to wait and see how that's applied in this case. But I think this will be a good case for Second Amendment rights. I think it will clarify a number of things, and I think it will make it more difficult for the lower courts. And this is really what the problem has been since the Heller decision, which established that the Second Amendment protects the individual right to keep and bear arms, not some collective right or state right. And it's been in the lower courts, they really haven't taken that Second Amendment protection seriously. And they have upheld a number of laws, such as assault weapon bans, magazine bans, these sort of what they call the may issue carry laws. And I think that hopefully this decision is going to help to rein in these lower courts and make them more serious about the Second Amendment.
Should we feel like we're on a trajectory in this country that is moving forward with protecting gun rights, or are we heading back the other way?
Well, I think that one of the very interesting things that has happened among the people, if you will, is that there have been a huge number of firearms purchased lawfully by people of all different political persuasions. And so now you have a record number of people in the United States who own guns. And I think the more people who own guns, the less powerful the anti-gun lobby becomes. And so it's just amazing when you look at the statistics of how many guns have been sold over the last 4 or 5 years. And I don't think it's all pandemic related, obviously, but typically these gun owners are going to be pro gun rights. And I think that's going to make it much more difficult for these. I mean, if you look at the public polling, there's a shift toward protecting gun rights and away from these so-called, sensible gun laws.
Dan, how do you see the gun issue here in North Carolina? I know we've got some pistol permit purchase laws in place that can be traced back to trying to keep African Americans from owning firearms. It would seem like those should have gone by the wayside a very long time ago.
Yeah, so a few interesting things on that. Through following the New York Rifle and Pistol Association case. There's a lot of really great amicus briefs there about the history of gun regulation. And there's one that I found that I thought was particularly interesting, not a group that I would have expected to exist. It's a group called Black Guns Matter. And they posted an amicus brief. They're a group of African Americans that basically their spiel is gun regulations are always racist. Even if they don't intend to be racist, they have a disproportionate effect on minorities, especially African Americans. I'm not certain in North Carolina how much of that is the case today. I will say our state constitution, and I believe it was the 1868 state constitution that specifically allowed the General Assembly to regulate the concealed carry of firearms. That is in my mind, that is a very different issue to what we're dealing with in New York. New York is saying open carry, having a gun, period, end of sentence, is something that we can regulate unless you get a license from us. That to me is a lot more concerning on Second Amendment grounds than dealing with the question of, okay, if we're gonna let you carry a gun concealed, who are we going to give that right to? Under what circumstances are we going to give that right? That's something I think we can have a reasonable debate on. But when we're talking about whether or not you can have a gun outside your home at all, period, end of sentence, the only regulations that I've been able to find on that issue have been either racially or religiously motivated regulations. And when I say religiously motivated regulations, I'm really talking about laws that predate the United States saying, if you're a Catholic, you can't keep and bear arms because Catholics tried to blow up Parliament, and we don't want, essentially treating Catholics like terrorists from, the 15 and 1600s, which there's not exactly a good provenance on laws saying you just can't have guns or can't have them outside of your home, period, end of sentence. So just as a policy watcher, I'm very happy that this case is coming down, because I think Heller was an interesting case, but it didn't really set out a rule that lower courts have applied well. And if we're going to have laws on guns, which I think we're going to have laws on guns, at least in some way, I want the rule of the Constitution to be clear of what you can and can't do. And right now, I think it's a mess what you can and can't do constitutionally. And effectively, what that's meant is lower courts have just been ignoring this right.
Greg, is it next summer when we expect a decision in this, or could it be sooner than that?
Well, traditionally, the court has held its most important, most blockbuster decisions until the last couple of weeks of June, which is the last business day in June will be the end of the court's term. And so they usually hold the big ones until then.
Speaking of big ones and blockbuster cases, that brings us to a couple of big abortion cases, one out of Texas, one out of Mississippi. I think the Mississippi case is the one that's getting the most attention as it's being cast as having the potential to overturn Roe versus Wade. Tell us about those.
Well,
go ahead.
Sorry. Go ahead, Dan.
I was just going to say, to me, these are the cases that I care the most about at the United States Supreme Court. The right to life is a critical issue. I mean, this is the John Locke Foundation, right? Life, liberty, and property are fundamental rights from John Locke's perspective. Inalienable rights. No one can take them without your consent. This is just the core of what it means to be a person, what it means to be a person who's endowed by God with rights. The Texas case, I think, is a lot messier than the Mississippi case. Texas passed a law, Senate Bill 8, that essentially lets private individuals sue abortion providers for providing abortions under certain circumstances. And that gives a minimum $10,000 award of money plus attorney's fees if you win in these cases. So there are some really weird procedural things going on in the Texas case. And the Supreme Court actually just issued orders on that last Friday, allowing the cases to proceed, but not putting the law on hold while the cases proceed. The Mississippi case, I think, is a lot cleaner. This is I think it's a 15-week abortion ban in Mississippi. So it's below the Roe standard. Basically, Roe said, okay, we have this difficult constitutional quagmire. Women have the right to bodily autonomy, according to Roe, and fetuses have the right to life. And I use the word fetus because that's the word the Roe court used. So how do we balance these two rights? So what we're going to do, Roe took a trimester by trimester approach in terms of who could regulate what. And then, of course, Casey versus Planned Parenthood comes along and says, really, the line is what we're going to term fetal viability. That is, could a fetus continue to live outside the womb without medical or even with medical intervention? Basically, if this child was born, would it be able to survive? And generally, that's medically accepted to be at 24 weeks. I think what's likely to happen in this case is we're probably going to ditch the viability rule. It seems to me like even the moderate justices want to get away from the viability rule. And when I say the moderate justices, really I have in mind Justice Roberts and Kavanaugh. I think they're really the swing votes here, but don't count Justice Gorsuch out. I wouldn't necessarily term him a moderate, but he is a free thinker. He's going to do whatever he thinks the text of the statute and the Constitution require him to do. And that sometimes, as we've read from his other opinions in, for example, Bostock, that sometimes leads him to some unique places from a conservative perspective. I think it's really, really important to note the tenor of the oral arguments here. It was, even for the liberal justices, they're not arguing abortion is a positive good. They're not arguing for women's bodily integrity. They're trying to say, okay, you need to respect Roe as precedent. If we start throwing out cases just because we don't like them or just because the public doesn't like them, where does that lead us? And that was the point that I was actually the most encouraged by Justice Kavanaugh on. An oral argument, he listed a whole line of very important cases that have overturned existing precedent. The most obvious one of those is Brown versus Board of Education. Everyone knows that one. Separate but not equal is not constitutionally allowed. There's no way to be separate and equal. So we can't have discrimination within school boards. And he basically said, look, the court does this all the time. And the most important cases that we have are often cases where we've overturned established precedent. So we need to throw that out. What's going to be really interesting here is if they step away from this fetal viability standard, what do they go to? It seems like there's an argument for what's called an undue burden, which I don't like the undue burden standard because I think it's entirely too mushy. Basically, it would be, well, are you burdening a woman's right to abortion more than is justified? Of course, the more conservative justices would say, no, there's no such thing as a right to abortion. And even if there is a right to abortion, then that's not in the United States Constitution. So just throw the thing out altogether. I would love if that were the decision, but I suspect we're probably going to see something of an overturning of Casey, but how far we go is a really interesting question. And the liberal justices, I don't think are trying to stop that. I think they're trying to limit how far the court goes.
You know, Greg, as I mentioned, we're seeing these cases being cast as the potential to overturn Roe versus Wade. Is that because it has the potential to get rid of the viability rule? Is that why people are saying, well, this would really get rid of Roe versus Wade?
If you put Roe and Casey together, you come up with this rule, which says states cannot prohibit abortions prior to viability. Now, Casey changed up some of the Roe framework, but that's the bottom line. States cannot prohibit abortions prior to viability. What Mississippi did was to say you can't have an abortion after 15 weeks. That's a different place where the state has drawn the line. Viability being at 24 weeks, Mississippi's law at 15. And so that's why this case is so important, because it goes right to the heart of Roe and Casey. This is not about other restrictions on abortions, like abortion providers have to have admitting privileges at a local hospital. This is really about the core of Roe and Casey. And that's why this is such a hard case. The United States is only one of 7 countries that has a right to, where women have a right to abort after 20 weeks. And most European countries, the time is somewhere around 14, 15, 16 weeks, like the Mississippi law is. So the question is going to be, what do they do with the Mississippi law? If you're going to uphold the Mississippi law, you either have to change the viability standard to something else, such as a woman's choice. And Chief Justice Roberts actually asked the question of those who were attacking the Mississippi law. What if we just said, that a woman's choice has to be meaningfully protected? Wouldn't she have enough time to make a choice within 15 or 16 weeks? And they went back to the viability standard. Chief Justice Roberts, I think, is wanting to change the standard to something else that would allow him to vote to uphold this law. On the other hand, the other option is to simply get the court out of the abortion issue altogether. And that's what Justice Kavanaugh seemed to suggest, where he said, maybe the court should just be neutral on this and then let the people speak through their elected representatives. I think that's probably going to be the majority opinion, which would be a huge change in abortion jurisprudence in this country. It would effectively overrule Roe and Casey and say that if women have a right to terminate their pregnancy, that right is going to have to be created by state or national legislatures, not by the Supreme Court. Now, there is another position too that some might want, that where the court would declare the unborn child to be protected life that is protected under the Constitution, and have the right to be born. So any kind of state laws that would permit abortion would be unconstitutional. I think as a matter of originalism, I don't think that's going to happen. I think it's a very difficult place to get based on an originalist argument. But I think the most likely is that they're just going to turn it back over to the legislatures to legislate there. They could uphold Roe and strike down the Mississippi law, but if they do that, I think we are at the end of conservative jurisprudence at the Supreme Court. That would be a complete capitulation and embracing of the living Constitution by our conservative justices. So I think it's probably going to goes back to the states, goes to the legislatures, or perhaps if they can come up with a workable alternative to viability. Chief Justice Roberts asked the other side, asked the opponents of the Mississippi law, can you give me another standard? He was searching for one, and they couldn't give him one. So we'll see how that works out.
Medical technology and science means that date of viability is constantly changing. And so, as I think there was just a story about a baby that was born at 23 weeks and has survived and is now, I believe, like a year old. So as we advance in our ability to care for children that are born very, very early, that viability standard may continue to decline there. That's interesting. But essentially, we have the potential here where each state would be making their own rules. So if you had a very progressive blue state, they could conceivably say, all right, you can have an abortion up to a full term. If you have a very conservative, more red state, it could be 6 weeks, 10 weeks, 15 weeks, or nothing.
Yes.
Okay.
And I think that this case highlights sort of a partisan difference that you'll find with, and I think that this is actually a fundamental sort of problem for conservatives like myself who are interested in the judiciary, which is I don't like judicial activism. I don't like the idea of just throwing out hundreds of years of precedent. I certainly think we should do that in the case of Roe versus Wade, but there are all sorts of post New Deal cases that set up presidential power and federal power to levels that I don't like and I don't think are consistent with the text or original public meaning of the United States Constitution. But conservatives, by definition, are not results-oriented justices. We don't think courts are just doing whatever they want or whatever they think is best. We think that courts should be limited by the original meaning and the text of the statute or the Constitution. So it's harder for conservative justices to come along and just say, well, we think all of these post-New Deal cases are just wrong, and we don't have to give you a good reason or a good constitutional reason to throw them out. So you sort of get this catch-22 where once the court has moved left, it's harder for the court to move back right because the left movement is often much more radical. I mean, when you read the Warren cases or when you read Griswold versus Connecticut, I mean, I once explained it to my friend by saying, this guy basically just hallucinates the spirit of the Constitution and says, the spirit of the Constitution told me you have a right to privacy. And there's not really much more to it than that. I can't imagine Thomas or Scalia or any of the conservative justices writing an opinion that moves that radically into sort of what I would consider personal will.
During these big cases that we've heard so far, has there been anything that came up or that was said or asked by a justice, particularly those newer members, that surprised you or that gave us insight perhaps into really the philosophy that being employed by a justice, what they're thinking versus what they might have said at confirmation? Anything stand out to either one of you or a particular justice?
Yeah, I think Chief Justice Roberts is trying to find in the Dobbs case, the abortion case, another standard, something other than viability, where to draw the line. And that doesn't surprise me. He's an incrementalist. He doesn't want the court on the front page of the newspapers. But I was surprised most in that by Justice Kavanaugh's questions and position, because I think that he indicated, because a lot of people think, well, Kavanaugh is sort of following in the footsteps of Chief Justice Roberts and really is more moderate than we thought he would be. But he was pretty strong in questioning two things. One was the whether the Supreme Court should just get out of this and let the legislatures decide, which seemed to be his preferred choice of how this should resolve. And then he also attacked this concept that the liberal justices were trying to defend of Roe somehow being super precedent that could not be overturned. And so I think both of those he pushed back. And I was surprised a little bit about the strength of which he questioned and pushed back on those two issues.
He was sort of implicitly comparing the defenders of Roe to the defenders of Plessy versus Ferguson and, segregation, which I think is about as strong as it gets. The only other big surprise that I saw at oral argument, and maybe this attorney just misunderstood the question, but one of the attorneys opposed to Mississippi's law was trying to make a history-based argument and say, well, a lot of states had the right to abortion up to viability before Roe and, before 1865 in our early republic. And there were these state court decisions. And Justice Thomas says, so what's your best case? And she doesn't cite a case. She makes a philosophical argument for it. Now, perhaps she just misunderstood and meant your best case is in your best argument. I have a really hard time believing that. I have done oral arguments before, not at the United States Supreme Court, admittedly. That is a very common question. I suspect every time I've had oral arguments at North Carolina Supreme Court, Justice Ervin has asked me that question, what case gives you this rule or whatever? What's your best case? I come to oral argument ready to cite that for whatever proposition I'm making. And if I don't have a case that really is strong, I'm ready to argue the point. So I would be very surprised if someone who's arguing at the United States Supreme Court, who I'm assuming is a much, much better attorney than I am and has prepared much, much more for this case than I do for my cases, because this is a major case, I would be stunned if she was not prepared with some sort of answer to that question. But it sounded a lot to me like she just ignored the question. The best interpretation for her is that she misunderstood the question. But to me, that shows how hollow these claims really ring, because I was very interested in the answer to this question, just as someone listening to the case. Because I would say Roe versus Wade fundamentally gets the history wrong here. So if there's some state court case from 1860, whatever, that agrees with Roe versus Wade's history, I want to read it. Please show me that case. And I think that that's exactly what Justice Thomas was saying. And he got absolutely nothing, which looks really, really weak to someone sitting behind the bench.
Well, gentlemen, this has been so fascinating. We could talk for another full hour on this. There's so much more that we weren't able to get to today, but our time is running short. So is it next summer then? Is June the time then, Greg, that we should be expecting to hear on these major cases?
Yes, I mean, if the court adheres to its tradition, we'll probably get the abortion. The two most important cases, I think, are obviously the abortion case and the Second Amendment case. And I won't really look for those before the end of June.
All right. And once those occur, we need to have you guys back and dissect what the opinion turns out to be and the impact of what it means for everyone who lives in this country. Greg Wallace is professor at Campbell University School of Law, and Dan Gibson is a partner with the Stam Law Firm. Gentlemen, thank you so much. Really appreciate you joining us and offering a fascinating conversation about things that will affect every single one of us. Appreciate it. If we don't see you before Christmas and the New Year, have a great holiday season, and we'll catch up with you in 2022.
Thank you, Donna.
And want to thank you
Merry
folks
Christmas.
as well for joining us here. This is our final virtual Shaftesbury Society for 2021. If you can believe it, we have made it through another year. So we're going to take 3 weeks off for a holiday break, and then we will be back with you on Monday, January 10th. And what we're going to do on January 10th of the new year is indeed just dig into what the new year could bring for us. We're going to take a look at the potential for the 2022 economy and, of course, politics as well. Going to have several members of the Locke Foundation and Carolina Journal team on board for our virtual panel on January 10th. So we are so appreciative to all of you who have tuned in and who have been engaged with us for Shaftesbury Society during 2021. Can't thank you enough for that. I would leave you with the message and question that I leave you with every week. If you like what you are seeing, if you like being engaged, if you like the work that the John Locke Foundation is doing, helping to inform and educate lawmakers about these critical policy decisions that they make that affect 10 million people, we would ask you to consider making a tax-deductible donation to fuel the work of the Locke Foundation. We are a 501c3 nonprofit organization. As you consider your year-end giving, we would hope that you would consider helping our work move forward into 2022. If you'd like to do that, just go to johnlocke.org. Fast, secure, very easy. Just hit the donate tab. In less than 2 minutes, you can make that tax-deductible year-end donation, and we would be most appreciative. Hope that you and your families and your friends have a great holiday season. Be healthy, be safe, be happy. Looking forward to a fulfilling 2022. We will catch you in the new year on January 10th. I'm Donna Martinez. Thanks for being with us.